Now call 123631, State v. Waldschmidt.
May it please the court, Corinne Gunning, Assistant Appellate Defender, appearing on behalf of Kylie Waldschmidt. Chief Justice, I would like to reserve 5 minutes for rebuttal.
5 minutes is reserved. Thank you.
A jury in this case convicted Kylie Waldschmidt of aiding and abetting felony murder of her boyfriend Diego Galloway, as well as interference of a law enforcement officer by making a false statement following that shooting. Kylie was accused of aiding a mutual friend of hers and Diego, Ryan Thompson, in committing the crime of aggravated battery with a deadly weapon or aggravated assault with a deadly weapon, ultimately resulting in Ryan shooting and killing Diego. The district court sentenced Kylie to life in prison with the possibility of parole after 25 years, consecutive to a 6-month prison sentence for the interference. So this is her direct appeal from her convictions and sentences. For the reasons, as I've stated in the brief, I believe that this court should vacate Kylie's felony murder conviction. Although the facts leading up to the shooting death in this case may seem a bit convoluted, the facts of the shooting itself are not. Kylie had taken Diego's debit card with the intent to retrieve money from his account that she believed entitled to because it was a tax return for both their children. After increasingly angry messages from Diego, Kylie and Ryan went to return his debit card to him. They drove to their apartment complex where Kylie lived with Diego, backed into a parking spot, placed the card on the hood, and called Diego to come out and get his car. Instead of coming to get his card, Diego came out of the building like a man possessed. He made a beeline for the passenger door where Kylie was sitting in the car, cursing and yelling at her, attempting to get into the car, trying to force the window down to get to her. Given the danger that Diego posed to Kylie in his concerted efforts to get into the car, Ryan got out of the car, told Diego to grab his card and leave. Diego ignored him, so Ryan grabbed a gun from inside the car, walked around the front of the car, and again told Diego to back off, take his card, and go inside. Diego finally responded to Ryan, said, "Fuck you, you ain't doing shit," and reached into his pocket. At that moment, Ryan believed that Diego had a gun, and responded by moving his hand with the gun in it. But Diego moved towards him and grabbed the gun that was in Ryan's hand. The two then fought over the gun, and Ryan, recognizing what might happen if Diego were to get control of that gun, put Diego in a headlock, hoping Diego would let go of the gun. He did not. When he continued fighting for the gun, Ryan pushed him away from the headlock, hoping it would force him to let go of it. This also didn't work, and so Diego lifted his gun towards Ryan with the gun in it, and Ryan pulled the trigger, shooting Diego and killing him. The entirety of this encounter, at most, as testified to by Ryan and Kylie, from the time that Diego came out of the apartment to the time that he was shot, took less than a minute. I have taken longer to describe the facts here than it took for that entire encounter to happen. It spanned the distance from one side of the car to the other side of the car, approximately from counsel table to counsel table. The entire focus of the event was Diego's violent outburst, which escalated to a physical fight, and there was nothing else that led to that intervened in this. While it was clear that Kylie did not kill Diego, it's clear that there's no aiding and abetting for felony murder. The state charged Kylie specifically with aiding and abetting Ryan in the felony murder of Diego.
She aid and abet in the aggravated assault or alleged aggravated battery.
I believe that was the discussion in the argument. And so yeah, I would say that was the argument, that she didn't aid and abet in the killing. She aided and abetted with the underlying.
What is your best argument that the initial alleged aggravated assault is not so distinct from the homicide as
the initial aggravated assault with Ryan coming around and displaying the gun at his side. I would say that my best for that is that is what, I mean, it was a response to Diego's violence towards Kylie, or attempted violence towards Kylie. So that the incident was already happening. It's a response to that. It's not separate and distinct. It's all part of the initial aggression from Diego. So it starts with him trying to get towards her. There's a non-deadly force response to that. And then it continued to escalate from there to the use of deadly force. So I would say that all of this is part and parcel of it, of all the events leading up to that. And I think if you're going to say that it's not an extraordinary intervening event as well, that it's not something so distinct from what the fight overall, the altercation overall, then it also, I don't know how it can be the felony, supporting the felony murder if it's not if it's not part of the event, if it's something separate and distinct, then it also cannot be a direct cause of the death. So I would say that I can't imagine the state, generally speaking, in most cases I've seen, would argue that that is something so separate and distinct that it wouldn't be part of the felony. It wouldn't be part of the whole event leading to the murder. But if that's the case, then it also can't. Clearly part of the entire.
I wanted to ask a preservation question on the prosecutorial error.
Okay.
I kind of, when I was doing my analysis in my notes, I broke it down into opening, closing, but then the middle ground were the questions asked of witnesses concerning child's parentage and the defendant's relocations, and there was no objection to those questions, were there?
I believe that there were, there was, it may have been maybe not the best objection, but I think objection is to relevance based on the questions that had been asked of her. I know there was a discussion in the record a little bit about why is he asking about the parentage? Well, we were talking about her relationship to Diego, so this is all part and parcel of it. So I
But
believe there was
I guess my point is, there needs to be an objection when we're talking about the prosecutors soliciting information from witnesses, as opposed to openings and closings, right?
Yes.
We just need to look at the record and see whether there's a proper objection before we even get into that.
Right. And I think that this court can look at that and determine whether or not the objection that was made is sufficient
Right.
enough. I have argued that I believe it is sufficient. I'll be honest, even without that improper questioning, that's kind of the last error that I have alleged. I think even without that improper questioning, if it's not preserved, the remainder of the errors I think are sufficient to.
I'm just trying to figure out, I just put each of those each of these allegations into different buckets. But the one about evidence is gonna, before I look in the bucket, I gotta find an objection.
Right, and I think it would just be a determination of whether or not the objection was sufficient to preserve that. Really just returning to briefly to the merger question. There was defense counsel moved to dismiss the case because the underlying charges in this case merged with the felonies. And by the time the trial happened, they had the benefit of Patillo. Nobody discussed it on the record. And so, I mean, very recently, this court has again reiterated the requirements for whether or not an underlying felony merges with the death. And I believe that there's nothing in this case that should demonstrate that the general rule for merger doesn't apply. There was a single incident, although it was 60 seconds instead of 10 seconds as in Patillo. I don't think that time is not determinative. We look generally at the time, overall time, distance and the causal connection. And there's nothing intervening in between there. And so I believe this court should find that those underlying felonies that were charged in this case should merge with Diego's death, and this court should vacate Kylie.
Before you're done, I have a
Yeah.
quick question about the self-defense instructions.
Yes,
They were not requested, correct?
they were not.
So the alleged error is that the court failed to sua sponte give the instructions. And then walking through the sort of typical jury instruction analysis, legally appropriate, factually appropriate, that makes sense. I am wondering if you know of any cases where we found a failure to sua sponte give a self-defense instruction is error. And the reason I ask that is because I'm just wondering if self-defense is different because it's an affirmative defense. And we've typically talked about affirmative defenses as things that can be waived.
Yes, I will. I don't have any off the top of my head because I think we for a long time have just continued to do that same analysis and apply the clear error standard. And
I could be very wrong about this, but I can't recall a case, at least in my time, when it's been the allegation is a failure to sua sponte give because they're almost always requested.
correct. And I, in all honesty, I believe that the reason that they might not have been requested in this case is because of the kind of the posture of the case that Kylie was not the shooter.
And that's why
So-
affirmative defenses have typically been described as waivable. So
Right.
I'm asking whether or not that kind of concept of waiving an affirmative defense might come into play here.
My best argument without having case law at the ready is that if it's an affirmative defense that is waivable, I would expect to see that waiver on the record. Otherwise, I think we're getting into some questions about, competent representation by counsel. But if this court were to work through this and say that perhaps clear error is not the only, is not the correct analysis, I think there has to be some sort of protection there for the client. That usually if there's a discussion, are you gonna request? No, we're not gonna request self-defense. I think that there was a question of whether or not it was even available. I'm not sure that some of the attorneys in this case might have thought that because she's not the shooter, she can't assert it. So I would say that there would need to be some protection for her rights in that instance. Unless there are further questions, I will.
Can you tie down the time element related to the activities Ryan Thompson, what Diego did after he came out?
Ryan's testimony is anywhere between 15 seconds from Diego leaving the apartment complex to getting to the car and Ryan getting out. And so then from Ryan getting out and moving towards Diego, it seems that his testimony is somewhere between 45 and 30 seconds for the remainder of that, depending on if you're going to include the initial knock it off and then going back to get the gun and walking back around. So 30 to 45 seconds from Diego getting to the car.
Keith, may I ask another question? Your opposing counsel mentioned that in his brief that he thought the fight was unforeseeable, so that the aggravated assault was complete, thus a basis for felony murder before anything else began. You brought up as response to that the sufficiency of the aggravated assault crime. Can you expound? I know that the evidence was that the gun was pointed down when he came out of the car, approached Diego, that it was Diego that grabbed the gun and brought it up horizontally so that it was aimed at himself, essentially. So can you address your position as to the sufficiency of the evidence if we?
As I say for sufficiency, if this court is to find that that initial aggravated assault was complete and done, and then the fight happens and there's other things, then there's no evidence of an underlying aggravated assault that is sufficient to support felony murder. Because in order to have felony murder, you have to have direct causation, and that the incident has to be within the res gestae of the death. And so if you have this act that you're saying is complete and done and not part of the death, then it did not directly cause the death. So
I understand that part of it. I'm asking you about the sufficiency of the ag assault.
well, I will say, as far as sufficiency of the ag assault, I don't think you can separate it from the felony murder because state did not charge her separately with aggravated assault. They charged her with aggravated assault as the underlying felony for felony murder. And that requires a relationship to the death.
It also requires an ag assault, doesn't it?
Yes. And from my position, I think it's hard to believe that, especially based on the arguments that were presented at trial and somewhat in the state's brief, that they would argue that, well, the fight that happened was unforeseeable. And then in the same breath, they say, well, he was going over there with a gun. Obviously they were going to fight. Kylie said, well, we knew, I was worried about a fight. So I do have some questions about the argument that it was unforeseeable and also that it was totally foreseeable. So I think that there's some tension there in the state's arguments as well. But I don't think that there's any, I would not feel comfortable making an argument that Ryan's display of a weapon was not an aggravated assault. The question is whether or not it was separate and distinct from the murder to support a felony murder conviction.
Questions?
Thank you, Your Honor. Aaron Joseph Cunningham, Assistant Alice County Attorney for the state. May it please the court. This is a classic case of heads I win, tails you lose. The defendant's entire argument in this under the merger doctrine is, well, if the ag assault is so close in time, relationship, and causation to the ultimate death, you lose because it merges. But if they can be factually distinguished to not be a key ingredient of the homicide as the statute requires, well, then it's so distinct that you don't even have felony murder. And so the issue that the state has in this case is we have to somehow demonstrate that the aggravated assault was a part of this equation, but it wasn't the key ingredient in the homicide itself. And that's what the state has set forth in this from the beginning, that the initial aggravated assault of brandishing the gun would satisfy that element, but it's not that initial brandishing that ultimately resulted in the death of Diego Galloway. There was an intervening struggle. The state has never held that it was not foreseeable that Mr. Thompson would use the gun for the aggravated assault purposes. But what the state is asserting is unforeseeable is that Diego Galloway didn't back down, instead engaged in a physical altercation. And because Thompson lost control of that altercation, made the conscious decision to pull the trigger and kill him.
Tell me what your best argument is that the ag assault, the original ag assault, was not an ingredient in the homicide.
Because that ag assault action, that conduct by Mr. Thompson in and of itself could have never killed Diego Galloway. This is so factually distinct from cases like Patillo or Sanchez, where we have in Patillo, for example, the drive-by shooting. It was the singular act of pulling that trigger and launching those bullets toward the victims in that case that resulted in their death. So it makes sense that that ag assault of hearing the bullet and the ag battery of the bullet connecting would merge. In the child abuse cases we have on felony murder, it makes sense that the beating of the child was the intent of the defendant in that case, but it was, I guess, somewhat unforeseeable that the child would die of those actions. In this case, the intent was to scare Diego. And when that broke down and Diego challenged Ryan Thompson by saying, "You're not going to do anything about it," that gave Thompson the opportunity to prove to Diego that he was going to do something about it.
Argument is that it must be the immediately preceding ingredient in order to be an ingredient.
Under the specific facts of this case, yes, I would agree with that framing of the
So
issue.
you can't have more than one ingredient that by a linear course of events leads from one action to the homicide.
I think that it creates problems about when hypothetically an aggravated assault could ever serve as the underlying felony in a felony murder case then.
Or when doesn't it? I mean, is there a case in when it is not where there isn't, where you wouldn't consider it an extraordinary intervening act? Seems that under your argument, ag assault would always satisfy.
No, I disagree. As I said, I think it makes sense in Patillo and Sanchez and the Lucas case that I guess really dealing with Patillo and the case involving the truck driver, which I believe is Lucas, it makes sense that those aggravated assaults would merge because it's the singular act of pulling the trigger. It's the singular act of driving the vehicle at the crowd of people. There was no response time from the victims in those cases that could even present an intervening action.
Let me ask you a question. The underlying felonies, the jury found that it was the first aggravated assault, which was showing Galloway the gun, right?
Correct.
And that was when the gun was pointed down, or is that your
Yes,
understanding?
my understanding is the evidence presented at trial indicated as he cleared the front, Thompson being he cleared the front of the hood, he had pulled the gun out and he testified Diego could see the gun at that point. That is the ag assault the state would be referring to.
Okay, and so and then at that point, the victim grabbed the gun, or?
It would depend on which account of Ryan Thompson's the fact finder would be inclined to believe, but yes, one of Thompson's accounts is that he then reached for the gun and proceeded to struggle with Thompson for the gun.
With it, okay, so he had it by his side, and then the victim sees it, grabs it. This is all fluid.
Correct,
Okay, and then there's a chokehold.
correct.
Okay, and or a headlock, I guess I should say, but you're not relying on the headlock as an aggravated battery underlying the felony, right? Because that wouldn't be aggravated because there's no weapon.
Well, the state's position would be that a headlock could be an aggravated battery and that it could cause great bodily harm. So obviously there are multiple theories to get to an aggravated battery. The use of the deadly weapon need not be involved to get to a theory of aggravated battery with a headlock.
But the prosecutor said that it was touching victim with the gun, right?
So, and yes, and the defense counsel in the, I guess their reply brief on this makes the claim that the state waived the argument of the headlock serving as one of the aggravated batteries. I would hold that the state does not, because the prosecutor also makes reference in that same quoted text in the reply brief that there were bruises on the face and cuts on the hand. And earlier in the testimony in the trial with the coroner, those injuries were, the cut on the hand was from the gun, but the bruising on the face, the coroner said, likely occurred as a result of the headlock aggravated battery.
And it's your position that those are separate, that those are batteries that are separate and distinct from the killing.
Yes.
Okay. And so from this, Mr. Thompson then was also charged with felony murder, right?
I believe that's correct. I didn't handle the prosecution of that case.
No, he wasn't. He was charged with murder and he pled to second-degree murder. Why would Mr. Thompson be charged with murder and plead to second-degree murder? And the woman in the car charged with felony murder based on aiding and abetting two underlying ag assault and ag battery when the primary person wasn't even charged with those.
The rationale for the charge against the defendant in this matter was her role in the actions leading up to this, which are documented through the Facebook message conversations, text conversations. And then she confesses to some of those preliminary discussions to Detective Burkholder in an interview that was admitted as evidence in this, where she discusses the plan was to rob Diego for the money involved. The aiding and abetting on her charge for the felony murder comes from the fact that she drove Thompson to the house to pick up the gun and then drove Thompson with the gun sitting in the
But the
seat.
underlying, but the felony murder is based on her aiding and abetting an aggravated assault, which was him holding the gun so that the victim could see it, and her aiding and abetting an aggravated battery, which is, as in closing argument, the gun touching the victim's head. Two things that the person who actually murdered the victim were not charged with.
I mean, I believe it's factually appropriate in this to charge Ms. Waldschmidt with these matters. I mean, we're not here on Mr. Thompson's appeal, and I wasn't the one making the charging decisions on that matter. But I think the reason the state went the route they went in this case is because of the preliminary efforts to entice and engage Mr. Thompson to carry out this aggravated assault or aggravated battery against Mr. Galloway. Going back to the distinctions between the different cases, it's the state's position that in the other cases, the intent is really what's driving the basis of whether or not the charge should merge. Again, the single action intent of driving a vehicle or pulling the trigger on a gun. But here in this case, we have the distinction in that we have these fresh impulses for Thompson's conduct based on the provocation of Mr. Galloway. And the state would point out that in the other cases, we have no clear insight as to what the intent of those defendants may have been leading up to that singular action that merged. But in this case, we do have a clear insight from the text messages, Facebook conversations, and the recorded interviews with the defendant in this matter, which set out that the intent was to start a fight, to rob him, and to get the money from him. And that would include the act of the aggravated assault that led to this.
What evidence was there that she wanted to start a fight? I understand the evidence that she wanted her part of the tax refund,
Yes.
that she wanted to start a fight. And
So
and
there's-
wasn't her initial plan that she was gonna go over there by herself, but Mr. Thompson insisted on going over with her? That's the evidence that I read.
That may be some of the testimony from the trial. The basis of that claim comes from the interviews with Detective Burkholder and the defendant, in which she's asked what she thinks was going to happen. She elaborates that she did anticipate there would be a fight. But moreover, the stronger evidence comes from the Facebook messages between Thompson and the defendant, where she makes reference to Diego, and excuse my French, needing to have his ass beat, and that he was causing problems in this. They had many plans to get the money leading up to it, but ultimately they made reference to this backup plan, which did involve the use of force.
Wasn't the backup plan, the PayPal plan? If they didn't get the money voluntarily, that they were gonna try to get into the account and put it and load a PayPal account?
That was a backup plan, but the order that those messages come in, I think, is more indicative that there was a potential backup plan involving force. And at the time that this all occurred, the testimony from the trial indicated they'd already tried the PayPal route and it failed because they didn't have access to his online banking and couldn't observe the transactions that occurred to verify the bank account.
Now, the quote about putting a pistol, using a pistol, that was stated by the prosecutor during closing. That she, I believe Kylie said that you can put the pistol down his throat, down Diego's throat.
I don't think that's correct. I think it was Thompson who made reference to, I can go around putting pistols down people's throats.
They never referred to it being his throat.
That's
It-
correct.
And that's what the prosecutor said more than once, didn't he? Put the pistol down his throat.
I don't specifically recall. It may have been. If you're saying it is, I have no reason to contest that.
But that would be error, wouldn't it?
I think based on the totality of the evidence that was admitted, I think it's a reasonable inference or conclusion based on the rest of the context of those text messages. And more importantly, based on the defendant's statement to Detective Burkholder about there being a plan to have Diego robbed and Ryan Thompson being the one to carry out that plan.
What's your best argument that the fight, that the aggravated assault was complete and the fight that ensued thereafter was not foreseeable? And
Candidly, I think most people, if they had a gun pulled on them, their natural reaction would be to shy away or not to lunge at the aggressor, as Mr. Thompson, I think, framed it in his testimony. I think, again, his introduction of the gun was totally foreseeable. However, Diego not merely backing down and complying was what was unforeseeable in that. And then the subsequent struggle was the intervening factor that cuts off, I guess, for the purposes of the merger doctrine, the link between that initial ag assault and his ultimate demise.
position is that someone who's been using meth, likely high on meth.
There's no evidence of that introduced at trial,
No evidence
that
that,
Diego was on meth or had used meth at that time.
so you're saying it was unforeseeable that his girlfriend, former girlfriend, coming with her current, possibly current boyfriend, is not going to enrage the old boyfriend.
I'm saying that the extent of the struggle and the lethality of it was unforeseeable in that Diego didn't just back down and go back inside after the gun was displayed.
But doesn't that assume that Diego would have believed that the gun wasn't going to be used against him? I mean, if you're standing there with a gun and you think somebody's going to actually use the gun, isn't it a natural reaction to try to disarm the person? Gun can't be fired while you're trying to get back into your apartment?
I mean, I think it comes down to a personal level, but I guess my position would be a reasonable person would probably become very compliant when a gun is introduced into a scene. Based on the context of the back and forth between Thompson and Diego leading up to it, it was clear Thompson didn't like the way Diego was interacting with the defendant. And I think that if at that point all it was verbal and someone pulled a gun, then I personally would shut my mouth and go back into my apartment. I don't know that I believe that a reasonable person would move closer to a weapon that could immediately kill them and attempt to disarm them. Certainly in action movies, that's something we see frequently, but in real life, most of the time when guns are introduced, people either draw their own gun or they become very compliant.
But is it so out of the ordinary that it's not a foreseeable event?
It's the state's position, it is. I mean, there's no evidence that would indicate that Diego had any comfort or familiarity with guns or I mean, it's just pretty unprecedented, I guess, in the facts in this case that this would happen. I see that I'm out of time. I don't know if there are any other questions. Thank you.
Thank you. 5 minutes.
Court. The state began its argument seemingly frustrated by the argument that I've made, which admittedly is a heads I win, tails you lose. But what I would respond is that Kylie is not responsible for the state's charging decisions in this. The state has the discretionary ability to determine what charges are appropriate. And in this case, they chose felony murder with 2 underlying felonies that have the potential of merging. And it did merge. And I, at the risk of kind of trying to go too far, I do think that there's very few cases in which those underlying felonies would not merge, that they would not meet both of those elements. The only cases I was able to find, Justice Rosen, were sort of transferred intent type cases. Otherwise, the examination of direct causation and the examination of murder, what you're looking at there are pretty similar, if not identical, analyses. And so I think that a lot of times those are going to merge, and that's the choice that the state made in this case. They did not charge those underlying felonies separately, and they, put all their proverbial eggs in the felony murder basket. I have unsurprisingly read many recent felony murder cases from this court, and would be surprised to find that the question for what is separate and distinct would be that the underlying felony causes the death, because many of the felonies in this case that are allowed to serve as underlying felonies are not capable of causing death. A drug transaction does not cause death. Robbery does not cause death. So to put that limitation on it, then it would negate most of the underlying felonies. Justice Standridge, you referenced the aggravated battery. I would say that the state functionally elected at their closing argument to argue that the battery is the touching of the gun to the head. And further, while a headlock could cause great bodily harm, that's not what the charge was. The charge was a use of a deadly weapon. And that's what the jury was instructed on. Um. More to say here, the, Justice Stiegel, I was looking, in response to the question that you asked about affirmative defenses. KSA 215108, subsection C says that a defendant is entitled to an instruction on every affirmative defense that is supported by competent evidence. That language is very similar to the language that says that a person is entitled to instructions on all lessers that are available. That burden is the courts, to provide the instructions. And so I think there is a statutory provision that controls that. But, you know, just for obvious reasons, I'm hoping that is not something that is decided in this case. For all that we have discussed, if there are no further questions, I would just argue that this court find that the underlying felonies charged in this case merge with Diego Galloway's death, and that the state has not proved an underlying felony for felony murder must be vacated.
For the questions, so thank you.
Thank you.
Thank you to both counsel for your arguments in this matter. The court will take the appeal under advisement.